Sometimes a will is shared after someone's passing, and instead of bringing clarity, it actually leaves people with real questions. Maybe someone who was thought to be included has actually been left out. Maybe the will does not match what was always said would happen. Or maybe the way the will was made feels concerning. For example, it was signed when the person was very unwell, under pressure, or after a sudden change in relationships. Now, in this video, I'm going to explain what contesting a will really means in England and Wales and how the process works in practice. We're going to look at how to reduce the risk of a challenge when making your own will, and I'm going to share a few key facts and figures from our own dispute specialist partners at IDR Law, and provide more details about a very helpful tool designed to give clarity if you are unsure about where you stand. When people say they are contesting a will, they are usually talking about one of two very different legal routes. The first is saying a will is not legally valid because something was wrong with the way it was made. The second is accepting that the will is valid, but saying it has not made a reasonable financial provision. These routes have different legal tests, different evidence, and different time limits. So the first and most important question is always which route applies. First, let's take a look at challenging a will based on its validity. In England and Wales, a will must follow strict legal rules. When there's a serious dispute about whether those rules were met, it falls under contentious probate. And the main grounds for challenging validity are as follows. Number one, the will was not signed or witnessed correctly. Under the Wills Act of 1837, a will must be in writing, signed by the person making it, and witnessed by two people who are both present at the same time and then sign themselves. If any part of that process wasn't done properly, the will may be invalid, even if it genuinely reflected what the person wanted. Number two, lack of mental capacity. The person making the will must have had mental capacity at the time it was signed. This is judged using a long-established test from a legal case called Banks and Goodfellow. In simple terms, the person must have understood they were making a will, had a basic understanding of what they owned, and recognised who might reasonably expect to benefit. Concerns often arise where someone had dementia, was seriously ill, confused, or heavily medicated at the time. Number three, undue influence. Undue influence is where someone is pressured into making a will they would not otherwise have made. That pressure might involve control, emotional manipulation, isolation from family, or dependency on one person. It's often difficult to prove because it tends to happen behind closed doors. But if it is established, the will may be set aside. Number four, fraud or forgery. A will may be invalid if it was forged, if the signature was not genuine, or if the person was misled about what they were signing. And number five, lack of knowledge and approval. This is actually related to capacity, but it's not the same thing. Here, the question is whether the person actually understood and approved the contents of the will they signed. This can arise where a will was rushed, poorly explained, or prepared in concerning circumstances. Now, let's look at the second way a will can be challenged. And this one often surprises people. Even where a will is legally valid, the law can still step in. And this is under the Inheritance and Dependence Act of 1975. With that act, certain people can ask the court for financial provision if the will does not make a reasonable provision for them. And this can include a spouse or civil partner, a former spouse who's not remarried, a child, including, in some cases, adult children, someone treated as a child of the family, or anyone who was dependent on the deceased. These claims are not about rewriting a will just because it feels unfair. The court looks at practical factors like financial need, dependency, health, housing, and the size of the estate. And you may have actually heard the old advice of leaving someone £1 so they can't contest it. That's actually a misunderstanding. If they are entitled to bring a claim under the Inheritance Act, the amount actually left to them does not prevent it. Time limits actually do matter, and most of these claims must be issued within 6 months of the grant of probate. It is worth looking briefly at how will disputes arise in practice and how often concerns can turn into formal challenges. Based on data and case experience from our dispute specialist partners at IDR Law, challenges to wills and inheritance claims have increased by around 50% over the last 5 to 6 years. Most disputes involve a mix of perceived fairness, family dynamics, and the financial impact of the estate, with lack of capacity and undue influence being the most common grounds raised. Not every concern leads to a successful claim, as suspicion alone is not enough. Even so, disputes can take many months to resolve, and more complex cases can actually run on for years, particularly where blended families or second marriages are involved. And this is why taking an early look at whether a claim might exist and which legal route would apply can make a real difference. And as a starting point, IDR Law provide a free online claim checker that can help you assess whether a claim may be possible and how it can be approached. There's no obligation, and we've actually put a link in the description below. If you decide to contest a will, the steps depend on the type of claim being made. And as we mentioned earlier, there are 2 main routes, and each follows a slightly different process. If you are challenging whether a will is valid, these are the practical steps that are usually taken. I'm going to go through them in order so you can see how the process typically unfolds. Step 1. Pause probate if needed. A formal notice known as a caveat is lodged at the probate registry to temporarily stop a grant of probate being issued. Probate is the legal authority that allows executors to deal with the estate, collect assets, pay debts and taxes, and distribute what remains. A caveat puts that authority on hold while concerns are looked into. It actually lasts for 6 months, can be renewed, and does not decide the dispute. It simply buys time. Step 2. Gather the key evidence early. This is where most cases are won or lost. So the focus is on facts, not feelings. If the issue is mental capacity, the most important evidence is medical, such as GP records, hospital notes, care home records, and the professional's file from when the will was made. If the concern is undue influence, it's usually about patterns. Things like isolation, dependency, sudden changes to long-standing plans, or someone controlling access. Statements from friends, neighbours or carers and a clear timeline can be crucial. If the problem is how the will was signed or witnessed, then the witness's account and the paperwork around the signing are key. A simple but powerful step here is to write out a timeline of events, including health changes, relationships and previous wills. It helps everyone see the story clearly. Step 3. Send formal letters and exchange documents. Before court is considered, solicitors usually send detailed letters setting out the legal basis of the challenge and asking for relevant records. The other side responds and negotiations begin. Step 4. Try to resolve things through negotiation or mediation. Most cases aim to settle at this stage. Mediation is very common in will disputes and involves a neutral mediator helping both sides explore a resolution without a judge deciding. It often saves time and cost and can help preserve family relationships. Step 5. Go to court only if settlement fails. If no agreement is reached, court proceedings follow. Evidence is filed, experts may be instructed, and witnesses given statements. The judge then decides whether the will is valid. If it is found to be invalid, the estate passes under the most recent earlier valid will. If there is no earlier will, then intestacy rules apply. Court is always the last resort because it is slow, costly, and very emotionally draining. Moving on now to Route 2, a reasonable financial provision claim under the Inheritance Act of 1975. Now, these claims focus on financial need and personal circumstances, not on how the will was made. And the usual steps are as follows. Step 1. Identify the deadline early. These claims normally must be issued within 6 months of the grant of probate or letters of administration. That deadline shapes everything, and missing it can be fatal to the claim, unless the court gives permission. Step 2. Gather financial and personal evidence. Here, the focus is on real-life circumstances such as income and expenses, housing needs, health or care costs, any financial support previously received, and the size of the estate, and other beneficiaries' needs. This helps show whether the will made reasonable financial provision. Step 3. Send a formal claim letter and exchange documents. A detailed letter is sent to the executors and beneficiaries explaining why the claim is being made, what is being sought, and the evidence relied on. Both sides then exchange key documents under the court's pre-action rules, which encourage early clarity and genuine attempts to settle. If this stage is ignored or handled poorly, the court can take that into account later, including when deciding legal costs. Step 4. Attempt settlement. As with validity disputes, most cases aim to resolve here, often through mediation, which is usually quicker, cheaper, and less damaging than court. Step 5. Issue court proceedings if needed. If settlement fails, proceedings are issued within the deadline. A judge then decides whether financial provision should be made, and if so, what form it should take, such as lump sums or ongoing payments or housing support. Contesting a will is not a single process. It splits into 2 legally distinct routes, and choosing the right one early affects everything that follows, including deadlines, evidence, and whether probate needs to be paused. In practice, strong cases are built on clear evidence and sensible early engagement, and most disputes are resolved through negotiation or mediation, long before a judge has to decide. If you are considering a challenge, please don't delay. Speak to a specialist as soon as you can, be clear on your end goal, and understand that the process can be emotionally demanding. Everything we've covered so far has been about contesting a will. Let's now talk briefly about what you could do to protect your own will and reduce the risk of it being successfully challenged. A sensible first step is actually having the will drafted by a professional and then making sure it is signed and witnessed correctly. This helps avoid basic technical mistakes, which are one of the most common reasons wills run into problems later, especially where family situations or financial arrangements are more complex. It can also be helpful to record capacity where there could be any doubt. In practice, this means keeping clear evidence that the person making the will understood what they were doing at the time, such as a legal professional's attendance note, a medical opinion, or written confirmation of their understanding. Where a will includes decisions that might come as a surprise, explaining those choices in writing can provide important context and reduce the scope for arguments later. Finally, where possible, try to avoid making last-minute changes. Sudden amendments close to the end of life are more likely to be questioned and can increase the risk of disputes. Taken together, these steps make a will far easier to defend and far less likely to be successfully challenged. Whether the concern is a will's validity or reasonable financial provision, getting advice early can make a real difference. Speaking to a professional you trust, whether that's us or another specialist, can help clarify options before things become more complicated. If this video has been helpful, please like, subscribe and share it with anyone who might actually benefit from a nudge to plan ahead. Remember, a little planning today can make a big difference tomorrow. So until the next time then, stay safe, stay informed and stay tuned.